Hello everyone, it's Tom Nevin here, Director at Loquitur, and today we're going to discuss some tips for expert witnesses when giving evidence under cross-examination. So as the name suggests, this short video will cover some tips for expert witnesses when giving evidence under cross-examination. As the name suggests, also it applies to expert witnesses only. For lay witnesses or factual witnesses, you should see our cross-examination tips video. That video applies to factual witnesses and also experts as well who are going to be giving evidence under cross-examination. We'll put a link in the description below. Part of the reason for our providing this short video is there is a lot of good information out there in relation to cross-examination, but not a lot of it has an Australian focus. Our slides and our training more generally has a specific focus on the Australian judicial system, and that's why we thought we might provide that information for people like you who are facing or looking to present evidence to the Australian courts. Now, obviously, these slides are very general. It's only a very short overview. And we could go on about this for hours, and indeed we do in some of our more specific training. So before we start, a bit about Loquitur. We offer specific courses for experts who are likely to be going through cross-examination in court. In those courses we go into much more detail with many strategies and tactics used by barristers. Teaching experts how, as a witness, you can firstly recognise what is being done to you, and perhaps more importantly, how you can respond effectively when it is done to you. These courses also give you a chance to practice what you've learnt through a series of mock cross-examinations. We do offer a series of other courses which are on the screen there. These courses can be specifically for lay witnesses and also for professional witnesses who give evidence as part of their day-to-day employment. So moving to the content itself, some tips for expert witnesses when in cross-examination. The first point is for the expert to stick to their area of expertise. The expert should not speculate on areas outside of their expertise and on which they are not qualified to give an opinion. Now, obviously, as an expert, you're engaged by the parties for the benefit of the court to provide an opinion on a specific area on which you are an expert and to inform the court on it. Now, it's a common strategy for cross-examining counsel to take you beyond that area of expertise. For example, say you're an orthopaedic surgeon and you're being drawn by the cross-examining counsel to comment on how that person's injuries might affect that person's mental health. Now, that can be used to discredit you. For example, Dr. X, you are an orthopaedic surgeon. The answer, of course, is yes. But you're not a psychologist or a psychiatrist, are you? No. So as a result, you're really not qualified to comment on the claimant's mental health. Well, no, actually, I'm not. And you can see how that will then lead to lines of cross-examination, that you are too closely tied to the case, and that perhaps you might be willing to say anything to help your client's case. So if you are being drawn, or you see you are being drawn on areas outside your expertise, don't. Second tip is to beware of challenges to the assumptions on which your expert evidence is based. And you should be ready to defend those assumptions as well. Now, obviously, your report is going to be based on assumptions, and again, another strategy is for cross-examining counsel to challenge those assumptions during cross-examination. You should think whether your assumptions are reasonable in the circumstances and how you will justify them. It's not enough simply to say, oh, my instructing solicitor told me to make these assumptions. Indeed, if you do that, it might lead to accusations of partiality. So the third tip, and indeed following on from the above, is to think about how a change to an assumption in your report and on which your evidence is based may affect the evidence that you provide. You should, as part of your report and indeed as part of your cross-examination, consider any obvious alternatives. For example, if your assumptions are wrong, they have to change or are incorrect. You should also be ready to explain the effect of certain assumptions being incorrect in cross-examination. And you should also then consider the utility or effect of your evidence if those assumptions are found to be wrong. Tip 4, be ready for attacks on your credibility as an expert. Again, this is another very common strategy that cross-examining counsel will use. These attacks can come in various forms. For example, they might attack your lack of experience, especially with respect to the other expert. If you have a history of providing evidence to one firm or one type of party, for example, personal injury plaintiffs or insurers. If you've published opinions, Twitter, Facebook, Instagram, news stories, or any sort of activism, they can be used to potentially discredit you. And of course, the big one is any conflict of interest. That's a big red flag for any attack on credibility. So, in summary, be ready for attacks on your credibility as an expert. Tip number 5 is to be prepared. Now, obviously, you have to know your own report. It goes without saying. But you should, where it's appropriate, know the underlying pleadings, the facts and issues to which your testimony will relate, and also the report or reports of any opposing experts. In particular, you should focus on the report of the opposing expert because that will obviously have challenges to your evidence. You should know from the report what challenges you're likely to see, what challenges you're likely to face. Again, this is pretty obvious, but it's worth reminding because it will always happen to you. What you should do is read each sentence in your report and ensure that you can justify it if indeed you are challenged on it. You should also look for inconsistencies in your report. These will be grounds for challenge to your opinion and your report. And obviously you look for differences of opinion with the opposing expert because these will be the obvious lines of cross-examination which will be used against you. Point 6. If you are listening to the evidence from the opposing expert witness, you should be prepared to assist your legal team during that process. You should be ready to pass notes on these points, but obviously this will depend on the court processes as to whether you can sit and listen to the testimony. Now, obviously during the testimony, technical points might come up, specific issues might come up. Now, having you sitting behind the counsel team, ready to pass notes, clarify points, cross-refer to where you deal with that in your report, for example, is very helpful for the counsel team. Offer to do that, and they probably will take you up on that offer if they can. Point 7. If possible, you should obtain a copy of the court's transcript and review your testimony. Quite often you'll be surprised how different your recollection of recounting it in person was compared to how it appears or how it's written on the paper. You should read and review that transcript in great detail, and that'll obviously help you provide better evidence in the future. You can usually get a copy of this transcript from your instructing solicitors. They're generally provided at the end of each day or perhaps at the end of the hearing. Tip number 8 for experts when in cross-examination is that once the judgment has been handed down, you should review the judgment with respect to your evidence. This is perhaps the most impartial insight you're going to get as to how your evidence was received, i.e. you're trying to convince the judge of your evidence and explain to the court what your evidence is, and what better person to receive that feedback from but the judge themselves. In most judgments, the judge will specifically deal with all the evidence given in cross-examination in that judgment, and will explain whether the court accepts it or not, and give reasons for that as well. They will often include a critique of that expert's evidence, and indeed you'll hope that the judge says something like, I found expert X was an impressive witness for these reasons, and the judge will often list them out. They'll often list out any criticism as well. So when you do get the judgment, read it in great detail, learn from it, and you'll be much better prepared for the next time. So that concludes our brief look at some general points to help expert witnesses in cross-examination. Our courses go into this in much more depth. We teach some very advanced strategies and countermeasures for experts in cross-examination, as well as in many other aspects of the expert witness process. Our courses also allow for the practical application of everything that the expert learns in those courses, and we give the experts a chance to go through some mock cross-examinations in quite some detail. If you have any questions or comments, please send us an email. Our contact details are on the screen. And if you'd like a video on any other topic, again, just let us know in the comments or send us an email. Please do share this video with anyone who you think may benefit from it. If you liked this video, you may also find our video on general tips for all witnesses in cross-examination somewhat helpful. We'll leave a link for that below. And our next video in this series will be one on expert witness report writing. We will leave a link for that one below as well when that video is released. That concludes our brief look at some general points for expert witnesses when under cross-examination. We hope you found it useful and got something out of it. Thank you for your time.